Today we will cover the topic fraud. As we have discussed that when there is no consent, there is no contract. So further it is required the consent should be free consent, and the consent when it is not caused by coercion, undue influence, fraud, misrepresentation and mistake, that time the consent is said to be free consent. So the consent given by party must be absent of coercion, undue influence, fraud. So let us discuss fraud in detail. The consent given by party it must be absent of fraud. The term fraud includes all acts committed by a person with a view to deceive. Deceive means to cheat another person. Fraud means deceit, that is to cheat by one of the parties, that is when one of the parties deliberately or intentionally makes false statements. So that is known as fraud because here the intention is to deceive the other party. So it is absolutely impairs, that is damage or harms the free consent. So the fraud means an action that includes the false representation or false assertion of facts, concealment of facts, and any promise with intention to deceive a person that amounts to fraud. So, fraud is defined under Section 17, a statement of fact which one party makes in the course of negotiations with a view to inducing the other party to enter into contract is known as representation. Representation means that is the statement of fact which is represented to the other party. So, it must relate to some fact which must relate to some material fact which is material to the contract. It may be expressed by words spoken or written or implied from the act and conduct of the parties. A representation, when wrongly made, either innocently or intentionally, is a misrepresentation. And misrepresentation may be number one, an innocent or unintentional misrepresentation, or misrepresentation may be an intentional, deliberate, or willful misrepresentation. So, willful misrepresentation or intentional misrepresentation is termed as fraud with an intent to deceive or defraud the other party, that is known as fraud. The former is called misrepresentation when representation is innocent or unintentional, that is known as misrepresentation, and the latter that when it is intentional or deliberate or willful, so willful misrepresentation is known as fraud. Misrepresentation of fact may be intentional or unintentional. Intentional misrepresentation has been termed as fraud. For example, A sells an article to B honestly, believing that it is a good. Later, it is found defective. So here, A statement is misrepresentation because here the representation he has made that is unintentional, that is not willful, and therefore it amounts to misrepresentation. If A sells the above article with full knowledge of its defectiveness, it amounts to fraud because here it is intentional, that is to deceive or to cheat the other person, and this amounts to fraud. The definition of fraud under Section 17. According to Section 17 of Indian Contract Act, fraud means and includes any of the following acts committed by a party to a contract or with his connivance. Connivance means with his full support or with his consent or by his agent with intent to deceive another party and thereto, or his agent, or to induce him to enter into contract. So number one, the suggestion as to a fact of that which is not true by one who does not believe it to be true. Number two, the active concealment of fact by one having knowledge or belief of the fact. Number 3, a promise made without any intention of performing it. So these are the element of fraud. Number 4, any such act or omission as the law specifically declares to be fraudulent. In short, these are the characteristics of fraud. Number 1, that when a party conceals the fact from the other party, that amounts to fraud. When a party promises to perform an act for the other party but has no real intention to fulfill or perform the promise. And number 3, the false representation of fact has been made to enter into the contract. So here, if another person act on the representation and thereby if he suffers damage or loss, then and then only it amounts to fraud. Explanation of section 17. Mere silence as to facts likely to affect the willingness of a person to enter into contract is not fraud unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. Illustration: A sells by auction to B a horse which A knows to be unsound. If here the horse is unsound, in that case here silence of A amounts to fraud, because having asked whether the horse is sound or not, and if here A keeps silence, that amounts to fraud. So A says nothing to B about the horse unsoundness. This is not a fraud by A, because here it is not the duty of A to speak. So sometimes silence is not amount to fraud. Another illustration: A sells by auction to B a horse which A knows to be unsound. A says nothing to B about the horse unsoundness. So this is not fraud by A. But if B is A's daughter and has just come of age, here the relation between the parties would make it A's duty to tell to B if the horse is unsound. Similarly, where B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing here. So A's silence is equivalent to speech, and therefore this amounts to fraud, because when there is a duty to speak and if a person remains silent, in that case it amounts to fraud. But where A and B are traders and enter into contract, A has information of change in prices would affect B's willingness to proceed with the contract. A is not bound to inform B. So this does not amount to fraud. So that depends upon the circumstances of each case whether silence amounts to fraud or not. Let us discuss dairy versus pig. A company was authorized by an act of parliament to run trams by steam power, subject to approval by the Board of Trade. The company had already submitted plans to the Board of Trade, and the company honestly believed that the consent would be given as a matter of course, because here the company honestly believed that they will get the approval. On this belief, the company made the representation or statement in the prospectus that the company has the right to use steam or mechanical power instead of horses. The plaintiff bought some shares on this representation. But here in this case, the Board of Trade refused to grant permission for the use of steam power, and consequently the company was wound up. The plaintiff therefore contended that the said statement or representation was untrue and sued the director for fraud. So it was held that the directors were not guilty of fraud because after being authorized by the Act of Parliament, they honestly believe that they would receive or they will get the approval of Board of Trade as a matter of course, and therefore their representation or was statement does not amount to fraud. Element or ingredients of act of fraud. To constitute fraud, these are the elements or ingredients are necessary. Number one, there must be a representation or assertion of something false. The representation must be false. Number two, within the knowledge of the person making it. So whenever the representation is made, that is within the knowledge of the person making it. That is the suggestion as to a fact of that which is not true by one who does not believe it to be true. For example, the prospectus of company did not refer to the existence of document disclosing liabilities of the company. This gave the impression that the company was prosperous. So it was held that non-disclosure amounted to fraud because if the existence of document relating to liability had been disclosed, the impression would have been quite different. Anyone who purchased the shares on the faith of this prospectus could avoid the contract. Second, there must be active concealment of fact. If a person, number one, conceals a fact, number two, which is material to the contract, and number three, it is his duty to disclose, it would be taken as a fraud on his part. The concealment is bad as a direct lie. Thus, where a policy holder applied for renewal of the policy but suppresses the fact that he was treated for a serious disease, then the policy is voidable for fraud. Another example, a horse dealer sold a mare to B. A knew that the mare had a cracked hoof, which he filled up in such a way as to defy detection. The defect was subsequently discovered by B. It was held that the agreement could be avoided by B as it was a concealment of a latent defect. Next ingredient, a promise made without any intention of performing it. It is well settled in England as in India that buying goods without the intention of not paying the price is a fraud which entitles the seller to resign, that is to withdraw or cancel the contract. For example, A purchases certain goods from B. He has no intention to pay the price of the goods, so it is fraud on part of A. Number fourth ingredient of fraud, act of fraud is any other act fitted to deceive. The man, as you all know that the man is very cunning in inventing new types of trickeries or frauds. Any surprise trick, cunning, dissembling and other unfair means that is used to cheat anyone, it, it amounts to fraud. Next, next element or ingredient of act of fraud is any such act or omission as the law spe- specially declares to be fraudulent. This clause refers to provision in certain acts which make it obligatory to disclose the relevant fact. Thus, under Section 55 of Transfer of Property Act, the seller of the immovable property is bound to disclose to the buyer all material defects. The failure to do so or failure to disclose defects amounts to fraud. Next point, can silence be fraudulent? Mere non-disclosure or silence does not amount to fraud. According to explanation to section 17 of this act, mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. The general rule is that a person before entering into contract need not disclose to the other party the material facts which he knows. Example, in this case, before letting his house, a landlord failed to tell the tenant that it was in a ruinous condition. The house was in ruinous condition. It was held that he was not liable in deceit, as the tenant should have inspected the house before entering into an agreement. Number Statutory exceptions. There are two statutory exceptions to the above rule. Number one, where there is a duty to speak, keeping silence is fraud. When there is a duty to disclose, non-disclosure of material facts amount to fraud. In Kiran Bala versus Bhaire Prasad Srivastav, in this case, the first marriage of the appellant, Kiran Bala, had been annulled on the ground that she was of unsound mind at the time of that marriage. She was married to the respondent, Bhaire Prasad, the second time. The fact of the annulment of the first marriage on the ground that she was unsound mind or she was an idiot, and also that she was under treatment for mental alignment, were not disclosed to the bridegroom, either by the girl or her parents. It was held that it was not the duty of the bridegroom to find out these facts, but it was the duty of the girl or her parents not to conceal these facts. Consent of the bridegroom was held to have been obtained by fraud, and the second marriage of the appellant with respondent was therefore annulled by a decree on nullity under section 12 subclause 1c of the Hindu Marriage Act. Second exception, when silence is in itself equivalent to speech. Such silence is a fraud. Sometimes keeping silent as to certain facts may capable of creating an impression as to existence of certain situation. In such a case, silence amounts to fraud. For example, B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A silence is equivalent to speech. If the horse is unsound, A silence is fraud. In this case, the relation between the parties would make it A's duty to tell B if the horse is unsound. Effect of fraud under section 19. A contract induced by fraud is voidable at the option of the party defrauded. Number one, he can resign or he can cancel the contract. Number two, he can sue for damages suffered because of non-fulfillment of the contract. Number three, he may ask for restitution. Number four remedy is he can insist on the performance of the contract on the condition that he shall be put in the position in which he would have been if the representation made had been true. Example, A fraudulently informs B that A's estate is free from encumbrances. B thereupon buys the estate. The estate is subject to mortgage. B may avoid the contract or may insist on its being carried out and the mortgage debt repaid by A. So here I have completed fraud. So in the next lecture I will be discussing misrepresentation. Thank you.